Now that separate but equal doctrine was overturned and the civil rights legislation passed, communities of color, after 32 generations of oppression, were able to fight for their rights in a legal manner. The school finance litigation is typically defined in three waves. The first wave litigation argued federal equal protection under the 14th Amendment, such as Serrano v. Priest and San Antonio v. Rodriguez. The US Supreme Court ruled that school funding is a state responsibility in San Antonio v. Rodriguez, and Serrano was the first case to successfully challenge a state's school finance system here in California. The second wave focuses on state equity litigation, challenging the state's education clause. And the third wave of litigation also focused on state adequacy cases that based on their state's education clauses. The Serrano II court decision affirmed the state equal protection basis and affirmed the trial court's order requiring that wealth-based funding disparities between districts be reduced by less than $100 per pupil by 1980. The Economic Impact Aid was developed in 1978 to provide additional funding for English learners, but these disparities were never disappeared. Proposition 13 complicated the fulfillment of the requirements of Serrano because of the limitations that it put on the legislature. It capped property tax at 1% and resulted in raising less revenue than the revenue limit in most districts, thus lowering down the amount of revenue generated for education. Although Proposition 13 protected property taxpayers, it removed potential funding for public education, causing further legislation to be developed in order to fill the funding gap, which has never come to fruition. Proposition 98 added a new formula that were used to determine the amount of funding given to public schools and community colleges. The next significant statewide school finance court case was not until 2000 with the Williams v. State of California. It claimed that the state of California had not provided them with equal access to resources, such as instructional materials, safe and decent school facilities, and qualified teachers. These were the same types of lacking of resources that were previously talked about in the early 20th century. Not until 2000 did we actually come to this court case in California. The result of this case led to securing funding to provide access to the very basic educational resources that these students should have always been receiving. Another decade passed until Robles Wong v. the State of California lawsuit was filed in 2010. The plaintiffs in this case alleged that the state's education finance system was unconstitutional and implored the state to create a new school finance system that would provide students their fundamental right to an education. However, the Supreme Court declined to review, the California Supreme Court declined to review the appellate court decisions in 2016, which stated that there was no state constitutional guarantee regarding a specific quality of education. That was here in California. California fundamentally reformed its school funding mechanism via the local control funding formula in 2013-14. The intent of this policy was to provide funds to school districts that are deemed high need. In particular, targeted categories included low-income children, foster youth, and English learners. The LCFF also comes with the provision that parents, community members, employees, and educators develop local control accountability plans. However, according to the Public Policy Institute of California, a report published by SEAL, and also a special issue that I co-edited in 2019, has shown many of the shortcomings of this new funding formula in California. In 2020, Proposition 15 was put on the California ballot and narrowly failed. This proposition would have required school buildings to be reassessed for tax purposes at least every 3 years. This would have, in part, rescinded Prop 13. There was unquestionably bad timing because it was in the middle of the COVID pandemic, the economic crisis, but it was disappointing that we could not have increased the level of funding or revenue generated for California children. And lastly, the COVID pandemic has shown inequity regarding school funding have been increasing. The Kayla case shows that the resources for students to access emergency distance learning content and resources, there's a huge gap between those students, Black and Latinx students, and those more affluent white students. Next. Now, before I state the impact of the litigation nationally, I would be remiss if I did not mention the renewed xenophobic and racist rhetoric and policy that occurred in the 1990s during Pete Wilson's administration, right? This is a pattern of continuing to scapegoat immigrant and racially diverse communities. This coincided with the influx of the Mexican and Central American immigrants, particularly undocumented families and children, to the state of California. California saw a major demographic shift with the rise of the Latinx or Latino population. They went from 19% of the population in 1980 to over 33% in 2000. Furthermore, California became a majority non-white state in 2000. And in fact, Latinos became the largest ethnic group in California in 2014. These three propositions in the 1990s illustrated the political climate towards immigrants, and specifically those of Mexican descent, from anti-immigrant, anti-Mexican sentiment in Prop 187, to affirmative action, to bilingual education with Prop 227, which was rescinded with Prop 58 in 2016.